woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger.
The woman accused of zipping her boyfriend into a suitcase and leaving him to die during a deadly game of hide and seek has filed yet another motion with the court in Orange County, Florida. But this time, she's hiring a lawyer instead of firing one. We're talking about the latest developments with Palm Beach County State Attorney Dave Aronberg. Welcome to Sidebar, presented by Law&Crime. I'm Elizabeth Millner. We told you just last week that Boone had filed a motion to dismiss her case, saying her constitutional right to a speedy trial had been violated. That motion was denied. Boone was arrested for her boyfriend's heinous murder back in 2020. But 4 years later, her case is yet to go before a jury. Judges in Orange County, Florida say it's her own fault. Boone went through 8 different attorneys before the court ruled she would have to go pro se whether she liked it or not. Since that happened, Boone has done her best to represent herself in court filings as well as in person. Now it seems Boone will be getting some help. Before we talk about the specific motion filed Friday morning, just before the holiday weekend, and the latest hearing on Tuesday, I want to bring you up to speed on some background. In February of 2020, then 42-year-old Sarah Boone was at the home she shared in Winter Park, Florida with her boyfriend, Jorge Torres Jr. Boone told detectives that she and Jorge had been drinking and playing games like hide and seek when he got into the rolling suitcase. She claims she forgot about him being in there and went to bed. When she woke up hours later, he was dead.
I didn't mean to leave him there. That's what I'm trying to tell you.
You got up and walked away. How is that not intentionally leaving him there?
Because I'm looking at the hole knowing that it's there. He'll get out no harm. Because you don't.
And then he doesn't, but you don't go check on him. You say you're up for 30 minutes, and he doesn't come up. You don't go down and check on him?
I'm in the bed.
But investigators found a video on Boone's phone that allegedly shows her taunting Jorge as he begs for help.
For everything you've done to me.
Sarah.
For everything you've done to me.
Sarah.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Stories like this one are obviously very tough, but they're important to tell. And part of the reason we're able to do so is from our great sponsors like Upside. And I want to take time to thank Upside for sponsoring this episode of Sidebar. So what's Upside? It's a free, yes, free app that gets you cash back on daily essentials like gas and groceries. It's actual real cash back too. Money appears in your Upside app that you can transfer straight into your bank account. So here's what you do. You download the Upside app, then claim an offer for whatever you're buying on Upside. I went to 7-Eleven and got some candy and some other snacks and used the app, and honestly, it's pretty easy. You can use the app at places like Shell, Exxon, and fast food favorites like Taco Bell, and that's just to name a few. To find out how much you could earn, download Upside or click the link in the description and use our promo code SIDEBAR to get 25 cents back on every gallon on your first tank of gas. Again, that's promo code SIDEBAR for an extra 25 cents back on your first gallon of gas. During her interrogation, Boone told the detectives that Jorge was an alcoholic and had been abusive toward her. They both had arrests on their record for domestic violence incidents. In fact, a little more than a year before Jorge was found in the suitcase, the couple got into an argument after a night out drinking. Boone claimed Jorge dragged her up the stairs inside the home and kicked her in the face. But Jorge said he was going upstairs to get away from Boone when she started strangling him, so he kicked to get away. Deputies couldn't determine who the primary aggressor was, so they arrested both of them. Jorge was charged with domestic battery. Meanwhile, Sarah Boone was charged with aggravated battery by strangulation. Those charges were eventually dropped. Investigators charged Boone with second-degree murder in connection to Jorge's 2020 death, and she's been locked up in an Orange County jail ever since. Since her arrest, Sarah Boone has been in and out of court, with hearings and appearances being delayed or rescheduled or canceled altogether. And throughout it all, Boone has been unable to work with any one attorney for too long. She's written hundreds of pages worth of letters to the judge, often complaining about the attorneys assigned to her. Those attorneys who she has called snotty, liars, duds, and buffoons all requested to withdraw from her case. Because Boone was declared indigent, meaning she can't afford a private defense attorney, she's entitled to a public defender. But the judge says she was out of chances and that this seemed to be a ploy to delay the trial. After Boone filed a motion to dismiss just last week, the court received a defense motion for continuance. So I want to go through that motion right now with Palm Beach County State Attorney Dave Aronberg. Now, Dave, here's how the motion reads. The defendant is set for trial by jury on October 7, 2024. The defendant has just retained defense counsel, and a notice of appearance was filed on Friday, August 30th, 2024. 38 days remain before trial. Defense counsel has met with the defendant 4 times at the Orange County Jail, August 20th, 21st, 26th, and 27th. And the notice of appearance lists her new defense counsel as James Owens. He's a criminal defense attorney with a law firm based out of Milton, Florida, hours away from Orange County. Now, Boone filed a motion on August 22nd looking for her case to be thrown out, but lists herself as the attorney. So it seems she met with Owens a couple of times, filed that motion, then met with Owens again, and let the court know she'd retained counsel after all. Now, Dave, we went from 8 different attorneys to pro se, now to attorney number 9. What are your thoughts on that portion of the motion and just your reaction in general to Sarah Boone actually getting an attorney now?
Well, it looks like her want ad paid off. She had a really unusual way of getting a lawyer. She did an ad in excellent penmanship, great calligraphy, good grammar. She said, "You want publicity with are you somewhat like adventuresome with a side of keen?" I'm paraphrasing, but the side of keen stuck out in my mind. And yet, yeah, she found a lawyer. And when the judge in this case said no more lawyers, what he meant was no more court-appointed lawyers. If you want to get some lawyer on your own who'll agree to do this, is crazy enough to do this, go ahead. But the date for the trial is set, October 7th. Now she's saying, okay, I got a lawyer. I'm probably going to ask the court to pay for it at some point. But right now I've got the lawyer on my own, and the lawyer needs time to prepare. Let's move it from October 7th.
And Dave, I want to continue reading this motion for you. It goes on to state, during these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of the Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense. Now, before we go on to the next part, what are your thoughts about the battered spouse syndrome defense?
I think it's smart to go there because there are really only 2 people who know exactly the extent of their relationship, and one of them is dead. So she'll get on the stand and she'll say that he was abusive, and yes, they were drunk that night, but she was in fear of her life from this guy. And could it sway a juror or 2? I mean, possibly, but she's not walking free. The only issue here is whether or not she's convicted of murder. She's being charged with murder here. And so that's why you have to have a requisite mental intent, the mens rea. If you can show that you were the victim of spousal abuse and you had battered spouse syndrome, then that could eliminate that requisite mens rea you need for a murder conviction, and it could become a manslaughter conviction. And that is her best defense. Not that she'll be acquitted of all charges, but that she could be found guilty of a lesser charge. I'm actually kind of surprised that she's going forward with this, because the sense I got from the other 8 lawyers who bailed on her was that she wanted, meaning Sarah Boone wanted, to claim she was not guilty. She was innocent in this, but the videos that she recorded herself show she's not. And I got the sense that the judge, the other lawyers wanted her to do this kind of defense. So to me, what's going to happen next is either she has capitulated after not getting a lawyer and said, okay, to the 9th lawyer, I'll listen to you for once, or this a combustible situation where she's going to force another lawyer to walk away, and then there's no way the judge gives her any forbearance for a 10th lawyer. That would be it.
And continuing with this motion, because of course it's pretty lengthy, it says, quote, undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts from directives from interested parties. Now, it is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defenses is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Now, Dave, the defense says, I need more time to go over all of this and prepare a case. What's your reaction to this motion?
I think it's a sound motion. This is what a defense lawyer is supposed to do. It would be an easy motion, I think, to get approved by the court, to get granted by the court, if it wasn't the 9th lawyer and she hasn't been told previously that that's it. But he says he's got exculpatory evidence on her phone and he needs all this time. Now, the exculpatory evidence is apparently evidence that provides some proof that they had a combustible relationship, that there was battered spouse syndrome. It's not what you can normally consider exculpatory, meaning evidence that would acquit her, that would clear her. It would just, to me, just be evidence that would reduce the conviction from murder to manslaughter and allow her to get out of prison before she dies.
And so, how do you think Sarah Boone was able to even retain counsel after all this time, especially if she was indigent and has no money, essentially?
Well, remember, she retained the first lawyer, according to reports. Of the 8 prior lawyers, one of them was retained by her. So she has been adjudicated as indigent or ruled indigent by the court. And for the last 7 lawyers, she's had court-appointed lawyers, and the judge said no more. But yeah, maybe she, found some money under the cushions, or maybe there's money out there that she didn't have access to before that allowed her to hire this guy. Or maybe it was just the want ad she put out that attracted this lawyer who wants this national publicity and is willing to work for free for now, hoping that the court will approve for him to be paid by taxpayers. That can happen, where they sign on originally as, yeah, I'm going to be your lawyer, and then we'll petition the court for taxpayers to fund me. That is going to be an interesting question for this judge who said no more lawyers, whether or not he gets paid. But for some lawyers, it's the publicity that can get you more business out of this. He's a lawyer in Milton, Florida. That's outside Pensacola. It's a small community in Santa Rosa County, otherwise known as the Garden of Eden, Milton. I bet you didn't know that, Elizabeth. But he probably is thinking, this is the biggest high-profile case I'll ever have, and it could generate a lot of attention and business for me in the future.
And let's get into that help wanted ad. Back in June, when the court first ruled that Boone would have to represent herself and wouldn't be granted any more public defenders, she cast her net out to the general public. This help wanted ad is a part of Sarah Boone's court record. She drew it up herself, writing across the top, inmate seeking attorney, looking for a prosperous challenge, ready for your close-up on national television. Are you zealous with the side of keen? Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. A list of required qualifications also came with that. Client inclusion at all times, extreme efficiency in listening, communicating, understanding, and maintaining faith in the client. And then at the very bottom, she wrote, invest in the oppressed, believe. Let's just kind of break that down a little bit. I mean, which is, to your point earlier, you did mention that this new lawyer that Sarah Boone now has will have national attention, will be kind of in center stage a little bit when it comes to the trial that'll be happening just next month. But what are your thoughts on this help wanted ad? Do you think that when Sarah Boone wrote this up in her jail cell, that someone would actually answer the call?
No, I did not, considering she went through 8 other lawyers. It's like someone saying, hey, who wants to be my new boyfriend? The other 8 others bailed on me in a short period of time. And yet you had, there's always a 9th who's ready to walk through that door. The one thing I'll say about that want ad, it was very well done. It was in like calligraphy. I mean, she writes very well. The zealous with a side of keen. That's the line that stuck out the most. And it attracted this lawyer. Now, I think it was more the national attention than the want ad itself, but the want ad got the national attention. So, here's someone who's referring to herself as the oppressed. She is going to be a handful as a client, and I am not jealous of him that he gets to represent her, because who would want this situation? But really, I mean, there's nowhere to go but up, because no other lawyers wanted to represent her. It looks like they've got her dead to rights because she recorded her own crime. Just a matter of whether he can tolerate his client, because she seems to be so difficult that everything will be a fight. So if he can hang on and stay with her until the end of the trial, yeah, I do think he'll get some business out of this. He'll look like a saint.
And with Owens responding to that call, like you had just mentioned, she had gone through so many different attorneys to the point where I kind of feel like this has been unheard of in a way. But what are your thoughts on, say, for instance, Owens can't even work with Sarah Boone? You have a month until trial. Do you think it's possible that that could also happen?
He knew what he's getting into. I mean, there's no secret of Sarah Boone. She's clearly not all there. I mean, normal people don't, zipper their boyfriends into a suitcase and then laugh at them while they suffocate to death. and then afterwards you lose 8 lawyers because of irreconcilable differences. They fire you to the point where the judge has had enough and said, you're going to trial regardless. So you put out this bizarre want ad, very well written, but bizarre. And so you know what you're getting into at this point. Anything can happen. You know also that she's locked up pre-trial. There are certain visiting hours. You can't just, call her in the middle of the night and say, what's up? Let's talk about your case. You've got to work within these parameters. So it's going to be difficult, but the expectations are low. And my belief is the key to happiness in this world is low expectations. So maybe this guy is doing the right thing by stepping into this. It's going to be the most high profile case I'll ever have.
And the motion continues to go on by saying the defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28, 2024. The defense counsel responded to her advertisement and was retained. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. The defense certifies this motion is made in good faith. Now, Dave, let's just break down that part right there as well, too, especially the part of not trying to delay the proceedings or abuse the process. Do you think Sarah Boone has abused the system in a way?
Yes, because the Sixth Amendment right to a lawyer is not unlimited. You don't get to have issues with your lawyer, get fired from them over and over and over again, and just get unlimited delays. That's what she wanted. She just wanted to have an unlimited amount of lawyers, an unlimited amount of delays. That's not how this works, because the people in the community, they have a right to have this trial go, and especially the victims' families have a right to have this trial go. The system does not subsist on defendants getting to choose the date of their trial, because if that were the case, then they would choose half past never. That's what she wanted. She wanted this trial never to happen, and eventually the judge said, enough. You've had 8 lawyers. We're not going to defer this any longer. We're not going to delay this any longer, and you're going to trial on October 7th.
And let's talk about Tuesday's hearing, where we heard for the first time from James Owens himself and the investigation he's doing into Boone's history.
I would like Billy Lane, who's seated in the audience, he is the investigator on the case, because of the claims that we're making that she's a battered woman. We need evidence to corroborate that, so there's a lot of history between her and Mr. Torres, involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these two, as well as we're trying to get together the 911 calls that Sarah made and others have made about the disturbances between that couple. So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary for us to prove a viable defense of battered spouse syndrome.
Again, Owens wanted to push back the trial start date so he'd have more time to gather information and go over all of it, but the judge denied that request.
All right, Mr. Owens, it seems like you've already started to dive into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in a judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, have such extraordinarily good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. This case has already been continued 16 times. As of the date of your filing your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation of trial is counterbalanced by the right to the effective administration of justice. In considering all the factors as set forth in Turner v. State, 311, 7th, 3rd, 185, and pinpoint 189, Florida 2nd DCA 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th.
Now, Dave, do you think that Sarah Boone's attorney should have been given more time to prepare for trial since it's starting just next month?
As a prosecutor, I'm glad it's going. Justice delayed is justice denied. She's had so many other delays, and the Sixth Amendment right to a lawyer is not absolute. You don't get unlimited delays because the people and victims' families have a right to get this thing done. But on the other hand, I worry that since her latest request for a delay was denied, that there's now a chance that a conviction could be overturned on appeal based on a violation of the Sixth Amendment. Generally, courts will defer to the defendant on Sixth Amendment questions. So I hope that this is not fatal to a future conviction. So I think if I were the judge, I probably would have granted one more extension just to be sure, even though you said previously you would not do it again. I do understand, though, why the judge would be frustrated. I mean, this is all because of Sarah Boone's own doing, because of her intransigence. She was unable to get along with her lawyers. That's why they kept having irreconcilable differences and kept firing her. So she only has to look in the mirror, which she won't because she blames everyone else for all of her problems. But this means that this case will be a lot tougher for her new lawyer than he expected because he's got to get ready for October 7th. And it's not easy when you have a client like this in a situation like this where she's behind bars, where you don't have 24/7 access to her. So good luck to him. But, you know, he took this job because of that one ad where he was zealous with the side of Keene.
And Dave, with Boone's trial still slated for just next month, what are your thoughts on what the trial could actually look like? And do you see any potential issues seating a jury in this trial because of the media coverage that's gone on so far?
I don't see any real issues seating a jury. I've had high-profile cases in my jurisdiction, and even in the most high-profile cases, you can always find a jury. You don't need a jury to be a blank slate. They can hear things about the case. They can even have formed opinions. The big question is, can they set them all aside? Can they just follow the evidence and the law? Can they set aside their biases, all the things that they know, and just focus on what's in front of them? And so, yes, you can get a jury in just about any case, including this one. I think the biggest challenge for prosecutors is to establish the requisite mental intent for murder as opposed to a lesser count of manslaughter, because she does have a legitimate claim that she was blasted drunk, the two of them. And so, yeah, that could eliminate one of the elements of murder where you intentionally tried to kill someone. It could have been just a drunken episode also involving someone who she was in fear of. That's where the battered spouse syndrome comes into play. So she's not walking free from this. She will be convicted of something. The question is, will it be murder or manslaughter? For the prosecutors, they want the top penalty and don't want her to get out of prison anytime soon.
And Sarah Boone's a very animated character. We've seen from hearings, she makes a lot of faces at the judge. Obviously, she's gone through several different attorneys to the point where they argue, obviously, that she's hard to work with. What are your thoughts on kind of how her demeanor will be and how it'll play in front of a jury once the jury is seated and once this case goes to trial?
Jurors notice everything. And so if she's going to act the fool at her trial, then she'll be punished for that. I know there are some who may say, well, she'll act like the crazy person she is, and maybe that will help her with the jury. No, the jury doesn't like to reward people who are ruled mentally capable of attending the trial, who are not claiming an insanity offense, but just are off. I mean, normal people don't commit this kind of crime. Normal people don't zipper their boyfriends up in a suitcase and laugh while they die. And so, of course, she's going to be unusual and weird. And that will work against her, because when she says, no, I'm actually quite normal, but I was just drunk at that time, they'll be like, nah, this is who you really are. What we saw in that video is really who you are. And I'd be scared to have you back on the streets. So if she acts up, she'll be doing so against her lawyer's instructions, and it will hurt her in the end.
And that Suitcase video that we've all seen very much, coupled with her interrogation where she denied, even swore on her son's life that she had nothing to do with Jorge Torres' death. What are your thoughts on how that'll even play in front of a jury?
Oh, yeah. Those videos where she's lying about her involvement, where she denied it from beginning to end. She's been denying this until they found those videos on her phone. That is devastating against her. That's really bad, because people hate murderers, but they also hate liars. And as opposed to someone who just felt really bad about it, was an accident. No, she's trying to cover it up. So that shows a lot of things about her and her character, her mens rea at the time. And I think that will be a big part of the prosecution's case. Her best defense is just to take the stand and say how regretful she was and how drunk she was, and this something got out of hand, and just hope for a lesser verdict. But it seems like she wants to claim her innocence. That's a reason, according to reports, that other lawyers dropped her as a client. They knew that there'd be no chance of an acquittal on all the charges once that video was shown to the jury. But she seems to be living in an alternate universe, and that's why good for her that she found a lawyer who either she has finally agreed to listen to, or is going to allow her to testify as part of this alternate universe, which will surely lead to a guilty verdict.
All right, Dave Aronberg, always a pleasure to have you on, especially here on Sidebar. We really appreciate your time. Before we sign you off, is there anything else about this case you would like to add?
No, it's just another Florida case. And, I, as a Floridian, as a fellow Florida man, I call myself the Florida lawman. You just roll your eyes when you see a case like this in Florida shown to the world.
All right, Dave Aronberg, again, thank you so much for your time today. We really appreciate it.
Thank you.
For now, it seems Sarah Boone's trial is still scheduled to start October 7th. Of course, we'll keep you posted and updated right here on Law and Crime and right here on Sidebar. But for now, that's all the time we have on this episode of Sidebar. You can check out more episodes and subscribe to us anywhere you listen to your podcasts, whether it's Apple Podcasts, Spotify, or YouTube. I'm Elizabeth Millner, and this has been Sidebar, presented by Law and Crime.